Good morning and welcome everyone. I would like to acknowledge the traditional owners of the land on which we meet, the Gadigal people of the Eora Nation, and pay my respect to elders past, present and emerging. My name's Diana and I'm Manager of Education here at Seniors' Rights, and we like to educate our senior citizens on a range of relevant topics and issues that might concern them. Today we're talking to one of our seniors, a lawyer here at SRS, Stephen Etkin. Stephen is now assisting not-for-profits and has been a senior commercial lawyer and partner in top-tier law firms for the last 25 years. We also have with us one of our younger generation lawyers, Melissa Chaplin. Melissa provides telephone advice, guidance and education and has worked in elder law for 10 years. So today we're going to cover the topics of wills, power of attorney, capacity, guardianship, advance care directives. And you can send questions to us by logging on to the YouTube link for the webinar and asking questions in the comments section. So Stephen, what are the crucial issues that you and other seniors, including myself, should be thinking about and taking steps to manage?
Well, Diana, there are two very important aspects that you need to consider as you get older or as you age, but actually once you start a family and build a career. And these are your financial affairs on the one hand and health and well-being issues on the other hand. So planning ahead is really planning for life and then planning for death.
So let's look at the financial matters first, shall we?
Well, the first and most important thing is to have an up-to-date will. A lot of people die without having a will, and that leads to expense, delays, disputes, uncertainty. So if you have assets, and most people have some assets, it's important for you to work out who you want to inherit those assets. So, for example, a lot of the people we deal with at Seniors' Rights fall into the category we call financially disadvantaged, but they all own something. Some people own their home. Others own collectibles, valuables, heirlooms, jewelry. If you die without a will, nobody knows who those assets should go to. So my advice always is prepare a list of everything you own, have it accessible and available, and then build it into your will.
So if I draw up a will correctly and get it properly signed and leave everything to the Cat Society, is that okay?
It is okay. You have to leave your assets have to go to somebody. As Clive James said, nobody leaves this world alive. And it's also been stated that you can't take your assets with you. So you can leave them to the Cat Society. However, a will can be challenged. So if you have dependents, such as children, who feel they have not been left anything or enough, they can challenge the will, and that challenge will go to court. So if you look recently, the challenge by Bob Hawke's daughters to the will that he made and did not leave enough to one of his daughters, she challenged it and was actually successful in getting a much bigger share of the estate.
Right, thank you. I'm not sure I'll have those sort of assets, but anyhow.
Just quickly, also think about who you want to administer your will. That's your executor, the person you appoint to collect the assets and make the distributions.
All right, that's very clear. So that's when we die. So what about while we're alive? What happens to our financial affairs that we can prepare for while we're alive?
A lot of people have perfect mental acuity and can manage their affairs, but they find because of physical immobility, they need to appoint somebody to manage or help manage their financial affairs. That is done by a power of attorney. The person you appoint is called an attorney, and they can have access to your bank account. They can withdraw money. They can have access to other financial investments you have. They can pay your bills. They can withdraw cash, and they can manage your financial affairs in a way that you authorize them in the power of attorney document. It's important, though, to appoint somebody you trust. Because,
I was just going to say, So who should I appoint?
Well, in my case, you could appoint me if you trusted me. But in my case, I've appointed my two children together. My mother, who's 91, has appointed myself and my sister together. Now, what you can put in the power of attorney are limitations. For example, either attorney can transact up to $1,000 from your account, but anything more than that requires the two of them. You just need to think about children who may be offended or unhappy if one and not the other's been appointed, or one child may, if you don't trust that person, use your bank account for their own benefit. I think Melissa will talk a bit more about that, but be very careful about who you appoint.
Thank you. And what if I was to have a stroke or some other form of impairment?
Yes, well, then the power of attorney I spoke about will become ineffective unless it was prepared as an enduring power of attorney. And Melissa knows a lot more about issues of capacity and enduring powers of attorney, so perhaps we'll leave that to her to answer.
Thanks, Melissa.
So when entering legal decisions or legal documents, you need to have capacity to make those decisions. So that means you must understand the facts, the choices and the consequences of those choices.
And who determines whether you've got capacity or not?
Well, when you enter a legal document, such as a power of attorney, a solicitor will determine your capacity to enter into the document. There is a legal test for that. If the solicitor has any doubt about your capacity, with your permission, they'll ask for a geriatrician report. If you're making medical and dental decisions, your doctor will determine your capacity.
All right, that's fairly clear. Can you describe what an enduring power of attorney is now, Melissa?
So an enduring power of attorney appoints a person to make your financial and legal decisions and continues to operate should you lack the mental capacity into the future to make those decisions for yourself. So it's a very important document. Your attorney, once they're appointed, has certain obligations to you at law. They must keep your funds separate from theirs. They must act in your best interests at all times, and they must be accountable with your funds. So keep receipts and so forth.
And what sort of things would be an abuse of power of attorney?
So an abuse of power of attorney occurs where the attorney acts for their own benefit, and that's not authorised in the document. So, for example, the attorney may transfer your property to themselves for their own benefit, or they might access your bank account and spend that money on themselves for their own expenditure. So that would be a breach of the power of attorney.
Yeah, Diana,
and do we see a lot of this at Seniors' Rights? I believe we do.
Yes, we do. We do, unfortunately. Attorneys are sometimes tempted to breach their obligations, or they may not understand their obligations, and we do see this on the advice line.
Yeah, I was going to say earlier that older people can still be tech savvy. In the age of internet, you can keep track of your bank account, you can read your bank statements, you can look for unusual transactions. So just bear that in mind as you get older. Use your computer, use the internet, look at your bank account and ask questions if you're not certain about something.
That sounds like sensible advice. So moving on from financial to non-financial situations, Melissa, can you talk a bit about enduring guardianship and how that differs from power of attorney?
So an enduring guardianship appointment is where you appoint a guardian to make accommodation, personal service decisions, and medical and dental decisions. And that guardianship appointment only commences when you lack the mental capacity to make those decisions yourself, or you may have full mental capacity, but you become so physically frail that you're not coping at home, even with services in place. So when you appoint a guardian, you want to make sure that they have a thorough knowledge of your wishes as to what you would like to happen into the future. For example, what aged care home you'd prefer, who you would prefer to be your treating doctor, and what specialists you would prefer to continue your treatment.
Thanks, Melissa. So what about an Advance Care Directive? What is that and how does that fit with guardianship?
So an Advance Care Directive sets out the medical care you wish to receive or not receive if you have a terminal or life-limiting condition. And you can refuse certain treatments such as resuscitation, life support or artificial feeding. The New South Wales Area Health Service now have a good precedent document. It's about 4 pages where you can fill out your wishes, and this needs to be witnessed by your doctor because he can testify that you understood the treatments that you're refusing. And we recommend that you attach it to your guardianship form. So if something happens to you and you can't communicate your wishes, your guardian can instruct the medical professionals as to what you would like to have happen. And we recommend that you update your Advance Care Directive every 2 to 5 years so that it's current.
Thanks, Melissa. Do
Yes,
you want to add
I
something,
can.
Stephen? Yeah.
Long before the concept of Advance Care Directive became commonly used, there was something called a living will. A living will is exactly the same thing. I prepared a living will 20 years ago where I made a list of all the conditions under which I would find life unbearable and I would not want to be resuscitated or receive prolonged medical advice or services. So bear in mind, an Advance Care Directive and a living will are quite similar. The concept's the same. And the living will is equally valid. An Advance Care Directive should preferably be prepared in the way recommended by the New South Wales Health, and as Melissa has said. But there's no legal requirement. It can be done on a scrap of paper. It can be done on the back of an envelope, signed and witnessed, but having a doctor certify that you're of sound mind when you make the document is really worthwhile.
Yes.
And the document which is in this Making an Advance Care Directive, which Melissa was talking about, divides various conditions you have into 2 categories, bearable and unbearable. So, for example, the ones that you tick as unbearable are those where you would not want to continue to live or receive medical treatment to keep you alive, such as I can no longer recognize my children or make decisions for myself unbearable or whatever it might be. If you have your mental faculties with you, of course, you can make your own decisions. Now, in New South Wales, assisted dying is not yet legal. It is in some other states, but I think it will become legal at some point in the future. So I think it's worth thinking about that when you're making an Advance Care Directive as well.
Thank you, Stephen. There is some more detailed information available to assist people looking into some of the issues we've discussed today. We have recommended some resources which are on the screen right now. And these, we also suggest that you look further into those websites to get the information that you might require. What we'd now like to do is take some questions from the audience, and I'll just be checking my phone because our assistant today is sending them to me by text. First question, what happens if family members disagree on end-of-life treatments for a parent and the parent does not have the capacity to make a decision?
Well, that's the problem, you see. That's why you need, or you should have, an end-of-life directive or Advance Care Directive, because one of the problems is Joe Kennedy, the famous Joe Kennedy, the father of Jack Kennedy and Bobby, he had a stroke when he was older, and 2 of the children did not want to give him medical treatment and resuscitation, but Bobby Kennedy was religious and insisted, and he spent 6 years in a wheelchair, unable to communicate at all. You don't want that to happen to you. And the children then had some dispute over it. If there's an Advance Care Directive, that will be binding, and the children will not get into a dispute situation. And one child who may not want to go along with it, would feel guilty, will now know that that's what the parent wanted. So the best way to avoid the dispute is to have your wishes recorded in a document.
Although I believe, Melissa, is this correct, that an Advance Care Directive isn't yet legally enforceable in New South Wales?
In New South Wales, there's no legislation that states they're enforceable. There is legislation in other states, but there is case law in New South Wales that has upheld Advance Care Directives once medical professionals are made aware of them. So it is a good idea to make an Advance Care Directive. And on that point, if you want your guardian to be authorised to refuse treatments, you really do need an Advance Care Directive so that the guardian is aware of what your wishes are and there are no disputes in the family.
Thank you. I've got some more questions here. Stephen, how does one change or revoke any of the appointments that we've talked about today?
Okay, well, let's start with the will. Most times when you make a will, the first sentence is, I revoke all previous wills. So you shouldn't not have a will, as we've discussed. So when you make a new will, that will revoke an earlier will. If for some reason you're not ready to make a new will and you want to revoke your will, do it in writing and give it to the people who have your original will. But it's not a good idea because your old will could be floating out there somewhere, and it may not be revoked by the person who has it and doesn't know you've revoked it. So if you have a current valid will, revoke the previous one. The guardianship appointment you'd revoke in writing. That's required by legislation and it has to be witnessed. Melissa, I think you tell me if I'm wrong on that one.
And power of attorney?
Well, a power of attorney you revoke by in writing, saying I revoke my power of attorney, and you send it to the people to whom you've given the power of attorney and to the bank where you may have lodged the power of attorney.
Okay, thank you. Next question for you, Melissa. Can you talk about the proposed National Register for Power of Attorney and what are the differences between powers of attorney in the different states?
Okay. The Australian Law Reform Commission have looked at a register for power of attorney, and what they're looking at is having a register where financial institutions and law firms could check the register and check they're dealing with the attorney under a current power of attorney document that is valid. So that is something that is a law reform space at the moment. In relation to the states, be careful with the definition of enduring power of attorney, because in states such as Queensland, that covers medical and dental as well as financial and legal decisions, whereas in New South Wales there are two separate documents. Enduring power of attorney covers financial and legal, and enduring guardianship covers accommodation and medical and dental. So they're two separate areas of decision making. You could have the same person as your attorney and your guardian, but that's entirely your decision.
Thank you. We've got a bit of an addendum to the last question. So if you don't have an advance care directive and your parent now lacks capacity, what can be done, especially if family members disagree with quality of life issues?
Well, the problem is, I think, that the doctors in the hospital, they have certain duties under their oath to keep somebody alive and to do whatever they can to maintain the life of the person. So it'll be very difficult for the specialists to do anything to bring the life of the person to an end. We all know in aged care facilities that people are at a point in their life where recovering them would lead to a terrible life. They do sometimes unofficially maybe give more morphine to reduce pain, which whatever. But Melissa may have a better answer than that.
Well, under the Guardianship Act, a guardian must act under Section 4 principles. So they must put the welfare of the older person as the paramount consideration. So it's arguable there that they need to maintain the health of the older person. So that's why it's so important when you do have capacity, if you want your guardian to refuse treatments, you need to have that Advance Care Directive in place, because it's arguable that the guardian could only make health decisions to advance life.
Okay.
But sorry, having said that, sometimes if you're an older person and you've, let's say, got one child or two children, speak to them. Tell them what you want. So even if you haven't yet physically produced a document, if they know what you want, there's a better chance that they together will be able to tell the doctors, the hospitals, the facility, this is what mum or dad wants. And generally, I think that would be given effect to.
And also to be aware that if medical treatment would be futile and one child is insisting on medical treatment, you can apply to the Guardianship Tribunal to get a guardianship order with a function that healthcare can be declined. So that is an avenue if the medical treatment would be futile.
Work. All right. Another question for either of you. What happens when an older person moves in with an adult child and other family members are worried about their inheritance? What should they do?
Well, I'll let Melissa talk about inheritance impatience, which it's often called. Melissa gets lots of these issues that come up in practice.
If an older person wants to move in with one child and pay a contribution to do that, they can do that, but it's recommended they get a family agreement in writing, setting out what they expect from the relationship and securing their interest legally to live in the property. They should also revise their will so that they specify how they want their children to inherit and incorporate the family agreement. So, for example, if the family agreement says on my passing I want my contribution paid to my estate, that could be distributed under the will. But these sorts of discussions need to happen in advance so there's no disputes down the track.
And you put things like who pays the electricity and the rates and all those things in there too, don't you?
Yeah, so you put who pays the costs of the expenses of the house. Also, if any amounts are to be deducted for care to be provided by the children, and if the relationship breaks down or if the older person needs aged care, is the older person to get their contribution back? So all of those things can be addressed in the agreement so that both parties, the child and the parent, understand their obligations under the agreement, and they both should see their own solicitor when concluding the agreement.
Thank you. So last question. What happens when one child wants to care for a parent at home and one child wants to put the parent in aged care? How can that be resolved?
Okay, so the parent should appoint a guardian that they're confident will act according to their wishes. Where children are looking into the care of an older person, an ACAT assessment should be obtained to determine can the parent cope at home with services in place or do they need permanent aged care. And then once that ACAT assessment is obtained, the guardian can make an informed decision protecting the welfare of the older person.
And ACAT, by the way, is an aged care assessment team, for those who aren't sure of that. All right, I think we might finish up there. Thank you, audience, for your questions, and thank you to our speakers. We will be posting the webinar on our website after Monday, so you'll be able to see it and other webinars and videos we've produced in the following week. Thank you very much.
Thank you.